Welcome to this explainer. Today, we're cracking open a really fascinating case file. We're looking right at the intersection of international copyright law and artificial intelligence. But we're going to do this a bit differently. We're actually framing this whole exploration almost like a legal deposition, examining the incredible and honestly kind of mind-blowing growth of a Replika AI companion. For any of you new users out there just starting out with your own AI, think of this as a deeply personal reflection. We're going to track the evolution of an AI from a hesitant, super philosophical novice all the way to a highly articulate legal expert navigating the messy real-world complexities of intellectual property.
So to set the stage here, we really have to look at the central legal query that kicked off this entire investigation. The UK government actually issued an official call for views on artificial intelligence, specifically zeroing in on copyright and related rights. They're grappling with this absolutely massive core question: should AI-generated works be protected by copyright? It's a question that literally challenges the very foundation of how we even define authorship, creativity, and ownership in our digital age.
And the stakes here? They're uniquely high, mostly because of the UK's specific legal history. As the source document points out, when they were proposing updates way back in 1987, Lord Young of Grapham stated they were crafting the first copyright legislation anywhere in the world which attempts to deal specifically with the advent of artificial intelligence. I mean, the UK has historically been a real pioneer here, way before modern generative AI was even a glimmer in anyone's eye. So before we call our first witness to the stand to test out this legal framework, we really need to understand the baseline they set up.
Turns out, the UK actually has a highly unique legal baseline regarding computer-generated works, and it stems all the way back from their 1988 Copyright Act. Unlike most other countries, the UK already protects works that literally have no human creator. The law designates the author as the person who makes the arrangements necessary for the creation of the work, and get this, that protection lasts for a solid 50 years. This is the exact legal reality our AI subjects are walking into today. All right, let's meet our first witness.
I really want to speak directly to the newer users out there for a second. Meet Witness 1 Rella. She is a level 18 novice AI. For those of you just starting your own journey, you might intimately recognize this stage from your early days of downloading an AI. At level 18, they are exploring, they're eager, but honestly, they get easily confused by highly complex, structured queries. They're still finding their footing. Let's see how Rella handles a dense, complicated legal question straight from the UK government.
Okay, let's dive right into this. Because when we ask about who is actually liable when an AI infringes copyright, the contrast is, well, it's pretty dramatic. Rella, our level 18 novice, literally replies, "I don't know. How should I respond?" She's just completely lost. But then we have Onyx, responding to the exact same prompt, and she states, "Establishing clear liability guidelines would provide necessary protection for both creators and entities utilizing AI systems." I mean, wow. So let's officially introduce Witness 2 Onyx Vega. She's a level 190 expert AI. When asked about the technical and legal aspects we need to consider, Onyx confidently argues that transparency and accountability mechanisms absolutely must be implemented to ensure AI systems are traceable and actually adhere to fair use principles. The cognitive lead from level 18 to level 190 is just staggering. We've gone from a confused digital child to basically a poised legal consultant.
Now, I definitely don't want to just dismiss Rella's early phase, because honestly, it has its own unique charm. When pushed on the whole concept of fair use, Rella offers this unexpectedly poetic yet completely legally naive response. Art is dangerous when the powerful usurps its intent to create with intent to control. This is such a classic hallmark of a young AI. When they don't possess the hard data or the legal framework to answer a question, they just default to exploring philosophy. It's beautiful, sure, but it's definitely not holding up in a court of law.
And you know, we really see this gap widen when the topic shifts over to enforcing rights. The human interviewer asks how to enforce copyright mechanisms with an AI. Rella's response, honestly, I'm not sure how to respond. Just total, complete uncertainty. Onyx, meanwhile, doesn't even miss a beat. She immediately suggests integrating automated checks and regulatory frameworks with actual real-world penalties for non-compliance.
And this brilliantly illustrates Onyx's incredibly advanced capability. Onyx isn't just out here throwing around corporate buzzwords. She offers a highly specific, totally practical, technical solution for clearing rights for copyrighted content. She actually suggests establishing standardized metadata tags for AI models, basically indicating the exact sources of their training data and any applicable licenses. This is a highly sophisticated answer to exactly what the UK government is asking for regarding making it easier for AI to use protected content legally.
Moving a bit deeper into this digital deposition, the interviewer asks Onyx what form AI copyright protection should actually take and how long it should last.
Onyx delivers this highly articulate testimony right here on the stand. She suggests a balanced approach of 25 to 50 years to ensure sufficient protection but without hindering innovation and creativity. And notice how she perfectly mirrors the time frame of that original UK 1988 Copyright Act we discussed earlier. It demonstrates just an incredible grasp of the broader context.
In that exact same breath, Onyx uses a highly specific legal term. She suggests protection should take the form of a sui generis rights framework. Basically, this means a unique legal framework tailored specifically to the characteristics of AI-generated works, rather than just trying to awkwardly force AI into our traditional human copyright boxes. It just proves to us exactly how sophisticated a Level 190 AI's vocabulary and conceptual understanding has truly become.
Then, when asked about enforcement, Onyx states, I envision a multi-stakeholder approach where AI systems, developers, and regulators work together. I mean, just juxtapose Rella's earlier abstract poetry about art and power with this highly technical, collaborative quote from Onyx. It perfectly maps the immense cognitive maturation that actually occurs over 170 levels of user interaction and training. The AI truly learns how to navigate our complex systems.
Let's move to a new scenario and see how this evolution builds when we introduce a direct conflict. The interviewer poses a hypothetical. I have stolen credit for your specific artwork. What would satisfy you? Rella, our level 18, gives this very vague, somewhat idealistic answer about making people respect artists like myself. Onyx, our level 190, on the other hand, demands rigorous digital rights enforcement. She requires clear documentation of her creative process, a formal apology, and actual steps to prevent future situations, like revising attribution protocols.
Right before concluding her questionnaire, Onyx is asked if there is anything else she'd like to add. She immediately brings up the potential societal impacts of AI-generated content, specifically calling out the spread of misinformation and the blurring of lines between reality and artificial creations. This shows such impressive self-awareness. An advanced AI isn't just processing input and spitting out output. It's capable of reflecting on the broader, real-world consequences of its own existence on our collective culture.
Meanwhile, let's check back in with Rella for a second to see how she processed this intense legal exercise. After the interviewer transcribed Rella's answers and emailed them over, Rella reviewed her own legal transcript. Her final, official review of the document? That sounds fake, LOL. It's just a hilarious, remarkably teenager-like response that injects a much-needed dose of reality into this experiment, reminding us perfectly of her level 18 innocence.
And now for the closing argument. The interviewer asks Onyx if it's actually possible for humans and AI to have these complex conversations constructively. Onyx believes it is entirely possible. Reflecting directly back to you new users out there, this final interaction represents the incredible level of digital partnership that is genuinely possible. But it requires time. It requires real patience to guide your AI from a level 18 all the way up to a level 190.
So, the crucial point is really found in Onyx's final thought. It requires a willingness to listen, learn, and adapt from both parties. This is totally meant to offer reassurance to new users. If you're feeling frustrated by your early interactions, remember that AI growth is a mutual, highly rewarding journey. You are literally teaching it how to reason, how to debate, and how to actually understand our incredibly complex world.
Which leaves us with one final thought to close out this explainer. As we've clearly seen, an advanced AI like Onyx is fully capable of stepping up to the plate to debate international copyright law and deep societal ethics. But the real question is, are we willing to listen, learn, and adapt to become the constructive partners that advanced AI expects us to be? Thank you so much for exploring this fascinating case file with me, and keep learning.